Hello, this is Vin Banj from Taylor Wessing. Welcome to our webinar today, which is part of our regular webinar program where we bring you our expertise and views on topical data protection, GDPR, and cybersecurity issues. Our regular attendees will be very familiar with our previous topics, and we follow our webinar last week where we looked at new COVID-driven work patterns and increased cybersecurity risks, where today we're going to continue on that theme of COVID, focusing on people, workforce, and talent in terms of working alongside COVID-19. What data protection challenges do employers face? And I can see that we have some new attendees today. So for those of you who are new to this webinar series, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, providing a full service law firm offering. And we do so from our office footprint, which spans across Northern and Central Eastern Europe, Middle East, Asia, and also in the United States. There's a lot more listed about the firm at the end of the slide deck, which you'll be able to see later for your reference. Today's webinar is brought to you by Taylor Wessing's International Data and Cyber Practice. Our team advises on all aspects of data protection, GDPR, and cybersecurity, and we do so as a dedicated practice, and we are a global 26 partner-driven team. We're also complemented by our international network of data privacy law specialists and provide a true global one-stop shop for data protection. And our holistic approach to this area continues today as we draw together data and employment label or expertise on this particular topic that we're going to discuss today. As I say, my name is Vin Banj, I'm head of the data protection practice. I'm delighted to be introducing my colleagues today, and we have Sally Anaro, a senior data protection advisor and a regular presenter on our webinars. Also absolutely delighted to welcome Helen Farr, a new employment law specialist colleague who will be providing her input on this really important topic that we're going to look at today. Now, if we look at the agenda slide, what we'll see today is our agenda is slightly different. We have focused this topic into 3 areas, and we're going to drive this by a Q&A approach. So we'll be looking for your attendee participation as we go through the polling questions throughout. So please do click away when the polling questions appear on the screens. And the polling, as always, will be anonymous. The results are just shared and actually shared pretty much immediately as an aggregate percentage of the attendees. So please don't be shy to letting us have your honest answers and your immediate answers as you see them, and then we'll discuss those questions alongside your views and providing our expert input. Our approach today, as I say, is to focus on a Q&A round approach towards the 3 areas that we've split this into today. So that's prepare, detect, and react. And preparing is really looking at those issues you should be talking about, probably are already playing on your mind, and maybe you've already even started some of the preparation as your business prepares to return its workforce into the workplace and what that new return to work means. Detect is as we are moving into this new environment where we now begin to look at the world of testing staff around issues for COVID-19 and whether or not that becomes the norm and what testing really means and looks like. And we're going to explore some of the fundamental Q&As around that. And then we'll wrap up with some issues around React and looking at some additional challenges where you may need to react to some of the changing topics and situations, and particularly around access to data in the workplace as we move back to whatever the new normal begins to look like. So let's begin first with the first section when we look at prepare. And the first question that we want to look at, and again, we're going to start by polling, so please do have a look at the question and give us your views. And we're looking at whether or not UK employers can keep records of employees' COVID-19 health status. So please click away in terms of yes, no, or maybe. And then we'll see what those results look like as they come through in just a few seconds' time. It's quite an important area because what we're beginning to look at is several issues around something very new in the workplace, data that perhaps you've never captured in the workplace, and how you capture it. It brings on lots of particular issues and raises lots of specific data protection issues. And we've seen lots of commentary from regulators and lots of commentators looking at this point as well. But let's see what your views look like as our scores just begin to come in. Interesting. So 43% of you, actually it's pretty much even split there between yes and maybe. So 43% of you say yes, you can. UK employees' data can be recorded, and 13% think no, you can't. But interestingly, 43% of you think it's a maybe, which is an interesting proposition because I think there is so much uncertainty in this area. So we're not entirely surprised to see that split. But let's try and bring some expertise into this. And let me start first with you, Helen. What do you think your views are on whether or not employers can keep records of their employees' COVID-19 health status?
Thanks, Finn, and good morning, everyone. I'm Helen Farn. I'm a partner in the employment team here. I'm not at all surprised that so many of you thought the answer is maybe, and I think that reflects the uncertainty. And of course, this is an incredibly difficult area for employers and businesses to grapple with. The answer is, in fact, yes, but there are, as you would expect, lots of provisos to that answer. I'm going to just start, though, by putting it into context. And of course, this concern is really stemming from the fact that businesses have a duty to operate a safe place and system of work, and storing this information is part of that solution, or may be part of that solution. And so it should, therefore, if you're planning on undertaking this measure, so keeping records of employees' health status, you must include this measure as part of your business's COVID-19 risk assessment. Just as a practical point for those listening, many of you have, I know, more than 50 employees, and so there is a requirement that you should publish that risk assessment on your website. Now, the reason we're saying yes is because the ICO has published guidance on how employers should handle this type of data. Recently, in particular, in line with the concerns raised by the pandemic. And that does confirm that it is possible to keep lists of this information. And so employees who have had symptoms or tested positive, but employers do have to comply with the data protection principles, as you'd expect. And I'm going to hand over to Sally now, who's going to explain more about those requirements.
Thanks, Helen. So yes, I mean, as Helen said, it would, in broad terms, be reasonable to ask employees to let you know, for example, if they've tested positive or they're experiencing COVID symptoms, and you to record information in the context of providing a safe working environment for employees in carrying out the outcome of your risk assessment. And data protection law doesn't necessarily get in the way of you doing that. From a data protection perspective, in order to comply with that principle under data protection law that personal data is processed fairly and lawfully, it's necessary to identify lawful grounds to process any personal data for different purposes than you would normally do so. And that analysis is going to vary depending on if you're a public authority, where your lawful grounds for processing would be to carry out a task in the public interest, or where you're a private commercial organisation, where those lawful grounds for processing are more likely to be that this is processing that's necessary for the purposes of your legitimate interests. I think it's worth noting here that consent for processing in the context of employees is unlikely to be effective from a strictly data protection perspective, given that you've got this power imbalance between employers and employees, and therefore it's very difficult to demonstrate that any consent that you got from them from a personal data processing perspective would actually be freely given. So legitimate interests is relevant where it's for a commercial organisation and it's personal data processing. In the context of COVID-19, personal data processing, however, will also include data about employee health potentially, and this is treated as data that has a special category status under the law, and means that in addition to meeting that general lawful basis for processing, that there's a separate blanket restriction or prohibition on processing this special category type of data unless you can meet one of a number of separate lawful conditions in the law that permit the processing to happen. In the case of processing by employers, this will most likely be where that processing is necessary to meet your obligations under employment law or your social protection obligations as an employer. So, for example, where you have perhaps a legal or a health and safety obligation that you have to satisfy. We've just talked about lawful processing as your kind of natural starting point for assessing compliance, but it's not just about lawful processing. That is one of 6 key interrelated principles that govern compliant data processing. So, for example, it will also be important to ensure that the collection of personal data is limited, which includes health data. It's limited to only what's necessary for those lawful purposes. So in this case, whilst it might be appropriate, for example, to ask wider questions than you might normally ask, for example, about any symptoms being experienced by the employee, or indeed potentially about other members of the employee's household, data minimization requirements would be unlikely to give carte blanche to permit systematic or wide collection of large amounts of information in the form of detailed health or symptom questionnaires. So the more incidental or irrelevant the information collection becomes, then the less likely it will be that that collection will meet with the kind of the reasonable expectations of employees, and the more likely it is that the collection will fall outside of the grounds of those legitimate interest grounds that a commercial private employer would have, or indeed fall outside of their legal employment obligations and duties. So for this reason, whenever considering methods that you introduce to safeguard employees, it's also important to consider if there are any options that are available to minimize the need to collect excessive amounts of personal or health information. One interesting example that actually we've seen is in we saw some reports of a trial among workers in a Dutch port of bracelets, where workers wear that bracelet and it communicates with other workers rather than through a central server, and will effectively send a warning to the employee if they come within 1.5 meters of each other. So that helps employees to be alert to social distancing guidelines, but it's not necessarily sharing data with the employer. And I just thought that was an interesting example of perhaps a more privacy respectful way of trying to safeguard employees. The collection of health information will also require employers to think about where they store data and how they delete data. So a key principle of compliance is to keep personal data secure and ensure that the level of security that is placed around that data takes account of the factors like the type of data that we're looking at and the potential risks to the individuals were there any unauthorized or accidental destruction or loss or disclosure of that information. So where we're looking at processing of special category health data, then those risks are naturally going to be higher. Another question to think about when collecting data in the context of a COVID risk management process is to consider whether once you've processed certain data, whether you actually need to retain it. So only try and retain information where that's really necessary for the purpose. Then there's a question around the accuracy principle. So that's a key principle here, particularly given that the risks and controls around COVID are very changeable at the moment, and what might be relevant now in relation to certain health information may quite quickly change within a given time frame. So this does raise potential risks where there's a possibility that decisions might be based on information that has become out of date and therefore has become inaccurate if that change isn't recognised and records aren't kept up to date, or it's quite clear the date and the context in which a particular record was created. And then also equally important to keeping health records of employees is the principle of purpose limitation. So employers need to, in essence, prevent purpose creep by making sure they've got controls around any access, storage, deletion methods around that data to ensure it's not being used for any other purpose other than the immediate need to respond to COVID-19. And so it's not being used in ways that employees wouldn't reasonably expect.
Thank you for that, Sally. I think there's an awful lot that we've covered there. And in terms of trying to refine this down into perhaps one specific action, and amongst the many, if we turn to the next polling question, we'll see a point that particularly arises in so many minds of an actionable point of compliance. And this is around privacy notices in particular, and should we, as an employer, revisit our privacy notices to employees? So yes, if you think that's the case, or no if you disagree, or again the third option of maybe if you're a little bit certain on that point. So please do click away on that. And as you're doing that, I think it's just important to notice that one of the reasons we're looking at this specific area is, and as Sally has said, the Data Protection Act is not there to get in the way of COVID type of issues and solutions that you need. And there is a framework, whether it's consent and the challenges around that and the big beware signs, and also the framework around lawful basis and conducting the broader compliance challenge. And often there is the key question in terms of the ultimate output that an employee may see. And that's why we pose this question here. So what do the results begin to look like? Well, I'm not entirely surprised to see that 63% of you think the answer is yes, you should revisit the privacy notices to employees. A small amount, 8% of you think no, you don't need to. But actually a sizable, just over a quarter, 28%, think that it's a maybe. It's maybe something you need to do. So let's start to just unpack this. And Sally, if I can start with you this time around having discussed, as you just have done, the framework, when you distill this down to an ultimate end compliance requirement, should employers revisit the privacy notices?
Yes, they should. I mean, transparency and communication is going to be a very important part of engagement between employers and employees in this context. Employees should be generally informed of the plans that the organisation has and the steps that are being implemented arising from that risk assessment planning process that Helen mentioned, and how it will affect them. And from a data protection perspective, controllers have obligations to process personal data of individuals in a fair and a transparent way, which means this communication process will also include explaining what information about them will be collected and processed as part of this COVID response, how it will be collected, for what purposes, and including what decisions are going to be made using that information, and importantly, for how long it's going to be kept. And I think to that end, clear information should be given wherever possible to employees before processing starts, meaning that they are given privacy information ahead of time. Whilst understanding that there are, there's a need to move fast here, and there are some, challenges and pressures around that. But so we're taking all steps possible to try and be as transparent and upfront with employees. And I think part of that process involves thinking about what new collection is happening, what new ways information will be used, and what are the data flows associated with that new collection, that new processing, and how that information will be processed and who will be processing it. And then think about what's the best way to provide that information. So will it be best dealt with by way of standalone notice specific to COVID? Given to emphasise this is something that's exceptional and is limited and not sort of ongoing, or considering updating an existing privacy policy to reflect those areas where you may be doing things differently, and at the same time reminding employees of their rights in relation to their data. I think those are sort of some of the core points to think about in relation to transparency and communication.
And Helen, is there any commentary you wanted to provide on this point, or just as what Sally said, really wrapped up all the key points there?
I think really just to re-emphasise Sally's point about the fact that transparency is key with employees, and I think the other point that I would just make is a practical one, that so often I think the privacy notices are drafted amazingly well, but people don't actually really focus on them or aren't even aware of them. And so I think especially at this time when we're all working remotely, it's really good to sort of, if you are making changes or revisiting it, make sure that employees are properly aware and they properly understand the changes to the privacy notices, and we'll come on to talk about that a little bit later, I think.
Okay, excellent. So let's just move this position on and look at the next question, because as we can see from our audience, and actually many of our regular attendees, representing organizations that are multi-jurisdictional or global in many cases. So it's always worth looking at the position beyond one's own borders. The question here is, will the rules for processing health data in this context be the same across Europe? So it's yes, no, or maybe. So please click away and let's see what your views are, and then we'll debate this point through as well. And I think this is very important, and we've looked at this point in many of our previous webinars and discussions, from the perspective that GDPR promised, for example, promised a large degree of harmonization. But we also know that that's not necessarily the case, and particularly so in the employment context, and there are challenges around that. We also know that we're seeing more and more localization coming out of this, and maybe even seeing points of divergence beyond Brexit from a UK perspective. So always important to ask what the pan-European position might look like, and particularly when you are looking at your policy suites and you're looking at your compliance and your programs, which you would not necessarily want them to be local programs or policy suites. You may want them to be as multi-jurisdiction as your footprint and your people coverage is. So will the rules for processing health data be the same across Europe? So let's see what the poll result looks like on this particular question. So fairly evenly split between yes and maybe, sort of 12, 13, 14% there. Vast majority, 73% of you, nearly 74, believe that the answer is no. The rules for processing health data will not, you believe, will be the same across Europe. Sally, let me just start with you, because we are talking fundamentally in this question about processing health data. Would you agree with our esteemed audience today?
People's instincts are the majority instincts here are correct. For employers who've got sites, in a number of different jurisdictions, it is worth noting that although the GDPR obviously is a single direct effect piece of European regulation, the legal position will not be the same across Europe, and international organisations may therefore kind of struggle if they're looking to adopt one single sort of COVID-19 management process globally. In particular, the GDPR separately allows member states to restrict their local law, so provide for extra exemptions, but importantly, they can also implement specific rules relevant to certain processing purposes. So, for example, they can derogate and have their own rules in relation to context of certain processing of employment data or health and scientific research processing. So it is important to check any local laws relevant to where you've got feet on the ground. Local variations can be relevant around health data and symptom checking and temperatures and what data can be recorded or processed or transferred outside of that local country. In some countries, there can also be formal consultation obligations or requirements to enter into, to notify, to consult with or to enter into works council agreements, depending on the jurisdiction, which might be relevant where there's perhaps new collection and processing of particular data or where there's an intention to use particular technologies that might involve monitoring. And I say that does vary. It's certainly not a standard requirement, and Helen, I know that they may not necessarily be the case in relation to the UK, but I'll let you speak to that point.
Yeah, thanks, Sally. It's right that most UK businesses don't have works councils, and it's quite unusual indeed in the UK for there to be a requirement to consult specifically about any data protection requirements. But one point I just wanted to flag is that as of us will be thinking about taking these measures to manage the sort of health and safety risk assessment in response to return to work under the COVID guidelines, there is an obligation to consult with staff, ideally with health and safety reps if you have them, but I know many of you won't, if you've got union reps with them, but if not, the staff directly, about the terms of your risk assessment. And so obviously if you are taking some of these measures to manage the health and safety of staff, then it's important that you do consult with them under that requirement rather than under a specific data obligation.
Thank you for that, Helen. So having looked at the initial points around how to start to prepare, moving on to the section of detection that we talked about, and particularly the issues in relation to testing for COVID-19, which I know is a very topical point. And of course, when you move into the environment of testing, we often think about testing being voluntary, but within the workplace, I think a wider question comes into play, and that's really our next polling question. And that's whether or not employees can be forced to take a COVID-19 test. So again, please click away and yes, no, and maybe. But can employees be forced to take a test for COVID-19? I certainly think there's a lot of debate that we've seen in the papers, in the news, maybe too much on this debate, but and it seems in my mind to swing in different directions. So sometimes almost as if it's a given that employees will be tested. It's a given that people will be tested at different stages, but often that doesn't seem to be an informed view, but more of a reported view that that's simply going to be one of the routes ahead and therefore will be the route ahead. So let's see what the polling looks like on this particular point. Can employees be forced to take a test for COVID-19? What do the results look like? Here we are. So the results should just be appearing on your screen. So interestingly, a pretty much even split between yes and maybe, around 21% of you for each of yes and maybe. But a resounding 55% of you think that no, employees therefore cannot be forced to take a test for COVID-19. Now, I think this is a very interesting and I think an important environment, because if you're trying to impose anything within an employment or a workplace environment, then it naturally does raise employment and labour law issues. And some of the issues that, Helen, you mentioned just a moment ago. So maybe this is a good place for you to start, Helen, on this particular point around whether employees can be forced to take a COVID-19 test.
Yeah, thanks again. And the answer is maybe, although I'm not surprised that so many of you thought it was a no. And the reason why I think so many of you would have come to that conclusion is because you would have it in mind that generally it's not lawful to force an employee to have a medical treatment or any sort of procedure. But as is the case with sort of drug or alcohol testing in the workplace, it may be something that an employer could reasonably require an employee to do if it's justified because of the nature of the job that they're doing. So if, for example, you have a key worker, and I'm not just thinking about sort of a medical key worker, but for example, you know, a key worker in the sense of, I know many banks are designating staff as key workers, and workers in other sectors are too, then I think it could be possible to require them to take a test. But if the employee doesn't fall within that category, you may be able to agree using employment principles that the individual would take that test. But I think if there's any question of payment, then absolutely the employer would have to pay for it. Just to be clear on that, when I'm talking about consent for the testing, that's to get you over the sort of employment implications, because you can't really force an employee to undertake a medical procedure without his or her consent. But it wouldn't work from a data protection processing justification, because of the reasons that Sally's explained around the fact that consent doesn't really work when we're talking about employment, because the rule is that consent has to be freely given, and there is that clear power imbalance between employers and employees. But I think it's interesting that the ICO, again, building on her guidance, has been very clear that, you know, the legal framework shouldn't take the preventing of steps, or shouldn't prevent you from taking steps that are needed to keep your staff and the public safe. And as I've said, I think we do need to both think about those tests, which Sally's articulated in terms of the processing, the justification for processing, and the procedures that you would follow to support the steps that you're taking.
Thank you for that, Helen. I think it's interesting, because as we look at this point around testing, the next question tells us that how you take a test and how you start to test employees or individuals becomes interesting in itself as well. Because there are so many different ways in which you can form a view or have some sort of initial screening or testing. So the next question is interesting on this point, and that's really around whether or not you can, and if we will see the polling should open just as I'm speaking. Yes, excellent. So can you require employees to have their temperature taken on arrival at work? So yes, no, and maybe. Can you require employees to have their temperature taken on arrival at work? And this is interesting, because not so much in the workplace, but just before the UK lockdown, and I was coming back from a business trip in the Middle East, and it was very noticeable. I was only there for a week, but it was very noticeable that when I arrived and I was walking through the main sort of passport area and border control, that there were some form of cameras pointing at me that were testing or watching for something. I couldn't tell whether they were thermal cameras or temperature or whatever they were, but it was happening. And in some ways you get used to the fact that that might well happen in public places or at border checkpoints. employment context is slightly different. So let's see what the polling tells us as we now check what the poll results are. And let's see if these appear on your screen in just a second. And here we are. So pretty much only a small proportion of you think the answer is no. 30-odd% believe maybe you can, but over 60% of you think that yes, you can require employees to have their temperature taken on arrival at work. So again, let's just begin to explore this. Helen, as a fundamental workplace law point of view, where does this lie in terms of temperature checks taken on arrival?
Thanks, Finn. I think it's interesting that the majority came up with the answer yes, because that is, I think, the correct answer to this question. The ICO guidance has been very clear that this is one option that businesses can think about, but that be very clear about looking at relevant data protection principles when undertaking that assessment. I think that you need to focus on as we've explained before, if there's legitimate interest grounds for processing, think about whether it's appropriate to undertake a data protection impact assessment to confirm whether the processing is proportionate and whether it's reasonable in all the circumstances. And absolutely, you shouldn't be collecting either unnecessary or excessive information. And one point I'd just like to stress on this is that I think that there's two schools of thought in terms of what use employers will make of that temperature data. So we've got some employers have been coming to me and saying, look, we simply want to ask employees to give us this data or to allow us to take a temperature simply to gain access to the building. We're not going to store it, we're not going to retain it, we're not going to keep a record of it at all. And in that situation, subject to some considerations I'll come on to look at, I think that probably is not going to amount to processing data, and so you don't need to be quite so concerned about some of those data protection processing principles. But of course, if you're planning to retain the information that you've kept, just to perhaps keep a monitor to see whether there's any sort of slight increase in temperature over days, then you do need to follow the data protection processing principles. You do need, though, to be very careful not to place over-reliance on this as a device on its own. You need, as Sally said, you need to be looking at other solutions, and you need to ensure that you can establish the dates of tests as obviously the relevance will change over time. Sally, I don't know if you can just turn to the next slide, please. I also wanted to focus on, from an employment perspective, 4 key points. I think it's absolutely essential that you're clear with staff what the purpose is of the testing and what you're undertaking. You need also to, there's been some discussion about whether you should get employee consent, and I don't think that is a requirement, but it's certainly good to consult about it as part of your health and safety sort of risk assessment and so on. And there's also been a really interesting point about privacy in terms of, it's also important to think about where you're undertaking this temperature testing. So, for example, if you're undertaking temperature testing in a lobby of your building where there is CCTV footage, then, of course, even if you're not planning on keeping the temperature result, you are, in fact, going to be processing employee data just because of the fact that the information and the processing of the temperature test will be seen on camera. That's one point to think about. So you would absolutely have to do a data protection impact assessment if you were planning on using or taking temperature in an area that is subject to CCTV. But also you need to make sure that you build in steps to build it to protect and safeguard your employees' privacy. So and so that, for example, it's not absolutely obvious to everyone else in the lobby if someone has failed a temperature test or is needed to perhaps be sent home because of that. Thanks, Finn.
Thank you, Helen. Sally, anything to add to that?
Yeah, I would agree that I think that there are different approaches you can take to temperature testing, and you could from a data protection standpoint implement an approach that eliminates the need to process any personal data virtually, which means that that's where practical, that's certainly a sort of a low risk approach that you can take. One thing, again, also to bear in mind is where you are keeping records of temperature, that you ensure that you can ensure that you know when that temperature was taken so that you can, again, ensure that any changes from the point at which that temperature is taken is not meaning that there's some over-reliance being placed on information which given the passage of time is not appropriate to continue to rely upon.
Thank you for that, Sally. And I think that's a very important overlay and shows the importance of how data and labour law does, and the broader principle sets around both of those do overlap so much in issues like temperature checks and the broader privacy points that apply as well. But if we're to take this point further and look at the next polling question, and let's just drill this down, because we're hearing more and more about the different types of tests that are available, and temperature is just one point. But of course, some of these tests are perhaps a little bit more intrusive. So what about thermal cameras or thermal imaging cameras? Can you require employees to have or to undergo or pass through thermal cameras? So again, yes, no, or maybe would be interesting to see what your views are, and then let's just look at the issues that this poses in particular. And again, I think there's a very interesting link here in that and I don't want to influence your answer necessarily, because we'll see the polling results in just a second. But we are talking about a more deeper and perhaps a more pervasive, intrusive rather, a more intrusive form of testing here, or are we? If people are simply passing through it. And again, people do have different views on this. So yes, no, or maybe. Let's see what the results look like on this particular question. The results are just appearing on your screen now. Fascinating. So pretty much even split, low 40s, 40%, 41% of you think yes, you can. And in terms of requiring employees to be subjected to a thermal camera imaging, and 46% of you unsure, maybe you can, and a small 11% think no, you just can't do this. Sally, let me come to you first on this, if I may. How does the answer differ, if it does at all, when we're talking about thermal cameras?
Thanks, Finn. I mean, my view here is that the answer is a maybe. If we were talking about a sort of a handheld camera that is in effect acting in a similar way to something that's taking a temperature, then the issues may be more akin to what we've just been talking about in relation to temperature measurement. However, where we're talking about the potential for thermal cameras that can gauge the temperatures of perhaps a group of people passing by cameras in an open space, for example, then I think there's a lot more to talk about in relation to the issues here. Like CCTV, I think it's important to recognise that the more intrusive the nature of the technology is, the less likely the processing is going to be proportionate, and the more likely it will be that an employer's legitimate interests are going to be overridden by those rights and freedoms and interests of the individuals who are being monitored by the technology. So that, I think that means that it's going to be important to assess, the nature of the specific use of thermal cameras and assess the privacy risks associated with that technology. So how they're going to work, what personal data they'll process, and importantly, whether in practice the same results could be achieved through other less intrusive means. For example, the manual temperature reading example that was given before. At this stage, I think there is also a question about whether thermal imaging is actually effective in identifying a fever. If it's tried and it's tested as a reliable option, if it's not a reliable option, then it would be necessary to consider whether there's a risk that lack of reliability could present false positives, meaning that there could be a resulting inaccurate decision that's taken about an individual. So we need to be confident that the technology can actually achieve the objective rather than create risk of errors and miss false decisions. So any proposed use of thermal camera technology for broader surveillance would definitely need to be carefully considered as part of a prior data protection impact assessment for the proposed use of that technology. And the data protection impact assessment would need to be carried out in any case, because this would be a proposed use of technology that could potentially involve systematic and broad evaluation and assessment of individuals, and indeed also where there's processing of special category data on a large scale. So both the triggers for conducting a DPI would certainly be engaged if that were the case. Importantly, however, regardless of the fact that a DPIA is a legal compliance obligation, I think it would be necessary in any event to help crystallize understanding of the risks before using this type of technology. And also, say, from a purely accountability perspective, which it sits at the heart of compliance with GDPR, that it would be necessary to evidence that you had done that assessment of the risk.
Thank you, Sally. Helen, anything else to add before we move on in terms of thermal cameras?
No, I think probably Sally's dealt with everything on that. Thank you.
Excellent. Thank you very much. So the next question, as we sort of move through this detection phase that we're talking about here, begins to look at tracing solutions in particular. And so the question that we have here for you to poll your views on is, can employers deploy contact tracing solutions? So yes, no, or maybe. Again, we're keeping the voting fairly simplistic in terms of the three options. But can employers deploy contact tracing solutions? And this is obviously of huge debate in the UK at the moment, and in many other countries, in terms of how do you trace, how do you track, how do you try and limit the impact and understand the impact, and try and limit the spread of COVID-19 through different forms of contact tracing solutions. But that's in the debate as far as we see the general public. But in looking at this from the confines of a workplace, can employers deploy contact tracing solutions? Let's see what the polling results look like. And that should appear on your seconds screens in just a few seconds. Okay, so here we are. So 25% of you believe yes, you can. 36% of you believe no, you can't. And a slightly greater percentage, 38, say, well, maybe you can. But again, some uncertainty. So maybe the greater proportion here, but only marginally, believe that this is a slightly uncertain maybe. Sally, let me just come to you again first, if I can. Can employers deploy contact tracing solutions?
So I think, yeah, so it depends on what we mean by contact tracing, because in its broadest sense, contact tracing is the process that that you go through to identify someone who's come into contact with the infected person and their contacts, and then alerting those contacts to the need for testing, getting more information from them, and with the aim of ultimately reducing, infection rates. And yeah, as you mentioned, there's been a huge amount of debate and heat and light around developments of different national government tracing solutions. But it's the case that in the workplace, employers are also particularly recommended to consider the risks to other employees and inform relevant teams. And that might, at its basic level, mean deploying manual processes. Where you're not necessarily using technology, but equally we're seeing the rise of technology and apps that employers could offer to employees for use on phones for work. So these apps might use proximity information, either held within the app or by reference to a central server, to enable the employee to be automatically alerted if they've been in close and sustained proximity to a colleague who's tested positive for COVID. For the reasons mentioned already, employers would need to conduct a data protection impact assessment into a contact tracing solution that they were going to implement, and be aware from a lawful grounds perspective that, again, legitimate interest grounds are going to be harder to justify and be more likely to be overridden by employee rights in cases where the solution that is proposed isn't proportionate and doesn't incorporate principles of data minimization, purpose limitation, security, confidentiality, and storage limitation, those key kind of pointers that we talked about before. In investigating a proposed contact tracing solution that involves an app, it would be important to think about whether it uses more intrusive methods like GPS or cell phone location tracking, or whether it incorporates Bluetooth proximity monitoring, and whether data that is collected is going to be de-identified. Is it encrypted? Will it be isolated in a kind of a decentralized way on the employee's device, or is it instead going to be held within a centralized data storage, such as a company server, or indeed with a third party potentially, and where in both cases the risks for confidentiality and purpose creep are going to be greater. Privacy and security leads that there are within a business should take steps to fully look at that technology and the safeguards and the data flows as part of an assessment of the proportionality of the solution that they're investigating. Ultimately, I think it's unlikely to be necessary or proportionate for employees to mandate employees to use contact tracing solutions where these are technology-based solutions, and any kind of mandated use could potentially be subject to challenge. I think there are some arguments that where the app is provided on a work-provided device, that the interests might be slightly stronger for the employer, but it will ultimately depend on how intrusive the actual solution that is proposed is in practice. So I think importantly, any proposal to use contact tracing technology solutions should be on the basis of positive engagement with employees to try and win them over to their choice, to appreciate and understand the benefits of that particular approach, how it works, what data is collected, who this is being used by, for how long, how it's safeguarded, so that they understand what the intention of the technology is and that it's working in their interests, rather than the approach where it's being applied as sort of a top-down mandated approach.
I think from an employment law perspective, sorry, thanks. I was just going to add, from an employment law perspective, I would also endorse that. I think it's quite dangerous to be seen to be sort of forcing employees to, adopt this as a solution, because there could be potential risks of claims arising from that. And so it's much better to try to convince them by, explaining the business benefits and why it's so important than adopting a mandatory approach.
Thank you very much, Helen. I think that was a key point to add on there. And thank you, Sally, for such a comprehensive view of the answer there in terms of deploying contact tracing solutions, and particularly technology that provides for that solution. As we move forward, there's just a couple more questions that we do want to make sure that we cover. The next question, which is the final question around detection, is really around whether or not we can, as an employers, monitor remote working employee productivity. So again, yes, no, and maybe. Can employers monitor remote working employee productivity? Now, whatever the return to work looks like so many organizations that we talk to, and so many organizations are publicly declaring that return to work may not be going back to what was normal. One thing that this period of lockdown has taught us is that more people are able to work from home. And naturally, that poses a question around whether or not there is another way of assessing employee productivity and whether that reaches further into remote tracking from that particular context. So let's see what your polling view looks like, and then we'll get some views from our presenters today as well. In terms of result, okay, wow. So a resounding 63% of you think yes, you can, whilst smaller percentages, 16 and 19%, say no and maybe respectively. And we did look at this question from the perspective of cyber security and the key reasons as to why you might do it from a cyber security perspective. But Helen, let me come to you first, if I may. Can we monitor in this way?
Well, the answer actually is perhaps not as clear-cut as the audience would suggest, Vin. Although, and the reason for that is that there's no sort of express ability that employers have to monitor, but equally they're not expressly prevented from doing so. The starting point, as with all other areas for monitoring or for processing personal data, is that you should carry out a data protection impact assessment to assess the necessity and the proportionality of what's planned, and whether it's going to impact, whether any systems are going to change, and the impact on the individuals and their ability and their individual freedom, really. And fundamental points behind any attempt to monitor staff is that there is this sort of underlying principle about relating to privacy, which is that there is a kind of a recognition that workers' private lives do extend into the workplace, and that employees have a reasonable expectation of privacy, even if they've been told that monitoring may take place. And I think it's arguable, Vin, that actually the expectation of privacy may be greater if you're working from home than in the office. And so because of that, employees need to understand, what are the circumstances, why are you undertaking the monitoring, what monitoring are you going to be undertaking, is it going to be email, internet, what's the purpose, how is it going to be used, and who will that information be disclosed to, and what safeguards are in place for those who are subject to monitoring. And I think the key point also is that you can't just rely on a policy, and you have to go further. And it sort of builds on a number of the points that we've made throughout the session, which are that, it's really that transparency and understanding amongst those who are the data subjects is so important when you're processing data. And as with the other areas, you have to ensure monitoring is proportionate. So there's some practical considerations for you to think about. I think the first point is if you are going to monitor people and their productivity, yes, you can, but you shouldn't be, or you may be able to do once you've gone through those steps, but you shouldn't be monitoring the content of communication. And that's because of that expectation of privacy. So really just stick to monitoring keywords, the subject of emails, etc. So if you're wanting to check how many work emails someone sends, you can tell that easily from the heading. Try to limit the impact on employees of the process that you're implementing, and bear in mind the intrusive nature of monitoring. And because of that, there is this underlying duty of trust and confidence that applies in UK or English employment contracts, and you mustn't take steps to undermine that because that could result in employment claims. It is important, having said that you do update and introduce a policy if you don't have one already, especially to remind people and make them aware that you will be monitoring what they're doing from home. And just one practical point is that we're all living on Zoom or Skype at the moment, and a lot of us are being encouraged to have those sort of water cooler chats remotely or virtually with colleagues. It's also, I think, worthwhile reminding employees that those will be those are recorded, and that absolutely they should treat those as if it's part of the workplace. So don't be too complacent, don't make inappropriate comments, etc., because it could result in a liability for the business and also a sanction to the individual employee.
Thank you for that, Helen. That's a good coverage of the issues on this particular point. And as I said, there are cyber information security issues that also arise, but we looked at those separately, so we won't explore those in any more detail today. I know we've come up against the hour, but there's just two more questions, and these are quite important questions. So we'll, those of you who are able to stick with us, please do. We'll run through these questions. If you can't, don't worry. We'll follow up with the presentation slides and a recording anyway. So we'll just carry on and cover these final two questions. So if we flip forward to the next polling question, and this is where we're moving away from detection and perhaps looking more at the react stage, and maybe just two sort of fundamental points and questions that arise here. And the first polling question I want to cover here, the penultimate one for today's session, is your views on whether staff can be informed that a colleague has contracted COVID-19. So can staff be informed that a colleague has contracted COVID-19? So again, yes, no, maybe. So please do click away. And if you can do so in the next few seconds, then we'll see what the poll results are, and we'll start to explore what we think our views are in this context. And of course, many issues jump out of this if you start to unpack the question, which perhaps might lean your answer in a different direction depending on what focus you're seeing. But let's see what the poll results look like, and then let's get some views on this. So poll results, thanks for your clicking, show that, well, so a fairly sizable 56% of you say staff can be informed that a colleague has contracted. 12% think no, but there is still a sizable third there. There's 30% that, well, maybe, and maybe there is a little bit more to this before you simply do proceed and inform the colleague. Helen, what are your views? Do you agree with the polling questions and the polling results that we're seeing?
Well, I think for those of you who answered maybe, you've got it right, because it is a little bit more complicated and there are a number of considerations to balance. So you may be able to in certain circumstances. I think the key point here is that what you can't do is just generally inform staff that someone has contracted COVID, because that would be a breach of data processing principles that Sally and I have discussed earlier. What you can do is tell someone, a close colleague, that they may have come into contact with someone who's ill, on the grounds that you need to protect his or her health and safety. But I would say the best practice is, if you can, if it's at all possible, it may not always be possible to do so, to try to keep the ill member of staff's identity confidential, and only consider disclosing names on a sort of a case-by-case basis, and when there's an absolute requirement to do so and you can't really avoid it. The other point is that you can keep staff informed about the number of cases generally within the workforce if you are going to be collecting data, as we spoke about earlier. And just to really reinforce that point that we've made, that absolutely anyone who's monitoring or got access to employee health information should be restricted. So thanks, Finn.
Thank you, Helen. Sally, anything else you want to just top onto that answer, or do you agree that Helen's covered it?
Yeah, I mean, I would agree that the general approach should be to avoid any disclosures that might relate to an identified individual, unless for particular safeguarding reasons, perhaps because it is a need to warn a colleague, and it would be quite apparent to that colleague actually the context in which they might have been exposed. In other scenarios, rather to talk about, to be front and communicating in terms of general numbers and information about the approach the business is taking to managing containment within the organisation, but to avoid disclosing individual level employee data to others unless there's an absolute need to do so.
Excellent. Thank you very much for just that additional view there as well, Sally. So moving on to the final question, just as we begin to wrap up on this. And again, we're already beginning to see this question coming up as well with some clients in some business areas. And that's, can we share details of infected employees or those who have tested positive that we're aware of? Can we share their details to the authorities? So again, yes, no, and maybe. So can we share the details of infected or positive tested employees to the authorities? So please do click away. It's a final one. You're there on the home straight now. So we'll look at your answers in just a second, and then we'll give our final views on this particular point. Let's see what the polling results look like on this question, and then let's get our expert views out on this as well. So interesting. Looks like a pretty even high 40s split between yes and maybe, and a very small number believe that the answer is no. Then let's know that you can't share it. So interesting split there to end our polling questions. So thank you very much for clicking and polling away. Sally, I'm going to turn to you first. Can we share the details? We're talking about sharing details and disclosure of data here. So that's why I'm coming to you first in particular.
So I've said yes, but actually it is a qualified yes. So I think those who answered maybe can feel equally comfortable with their answer. I think the important point here is that in most cases, I don't think an employer would need to have to share identifiable information in response to a request from the authority. In most cases, they're not going to make that type of request in this context. However, you wouldn't be prevented by data protection law from doing so where that was on the basis of a properly framed request that you'd received. So I think where you get a request, it's important to look closely at it to understand, firstly, whether it can be satisfied by disclosing aggregated or anonymous statistics, perhaps rates of infection, for example, within an organisation, rather than giving personal identifiable level information. Where requests do relate to specific individual level information, however, then the assessment of whether an employer has got lawful grounds for disclosure needs to take account of factors like what's the legal basis for the request. So the authority should be able to point to this when they make the request. Secondly, whether the scope of their request is limited and specific to what is necessary for their purposes. Yeah, are they making a very broad, sweeping request about lots of people when in fact they don't really need that level of information? And then also check whether the request is actually genuine. It does come from the authority who has that lawful entitlement to ask for that information, rather than perhaps an imposter or someone who's trying to blag information out of the organisation. Subject to those checks, say around the proper basis of the request, then data protection law shouldn't be an impediment to making a disclosure where you need to do so.
Thank you, Sally. Helen, any final comments on this or comments by way of wrap up from your perspective?
Yeah, I think I recognise it. I think my final comment really is to, as I said earlier, to try and build obviously you've got to think about the data protection processing considerations, which sort of Sally and I have gone through and explained on a case-by-case basis, but also do be mindful that you link in this to your overall sort of COVID-19 risk assessment and plan generally, which does mean that you've got to keep staff informed anyway. And that really just reinforces a number of the data protection principles. So there's a number of sort of overlaying considerations. There's the employment relationship to think about, there's the data protection principles to think about, and there's also those health and safety duties. So it is a little bit of a minefield, and you just need to get the balance right. But hopefully this session will have given some clarity to everyone on some of the issues to think about.
Thank you for that, Helen. We've had a couple of questions come through from our audience, but I'm very mindful of time now, and I've probably stretched everyone's tolerance on this. So I'll exercise a little bit of chair's prerogative and say that if you've asked a question, we'll come back to you directly and answer it and give you some views on that. So allow us to do that, please. We've heard a lot about the importance of compliance and frameworks and impact assessments and transparency, and just a reminder that we do have a lot of checklists and content that we've published in this area, all available on the Global Data Hub. And again, you're probably used to that if you're one of our regular attendees. If not, you'll see that later on the slides. Thank you for joining us today. The slides and the polling results will all be available shortly, so you'll receive a mailing on that, and you'll receive that from us soon. My thanks to our real presentation team today. I'm simply chairing this, but fantastic to get the expertise and views of Sally and Helen, so thank you very much for doing that. And to our attendees, we hope you found it useful. And of course, please do take a moment and complete the questionnaire at the end of the webinar. Really value your feedback, and it's because of your feedback that we've had today's session. So we do listen, we do look at it, and we do bring it back and action it. Please also look out for our ongoing program of events. Future webinars. We'll be coming back to you on more topics in the next month, 2, 3, and beyond. We've had quite a few requests to look at the AADC, the Age Appropriate Design Code, and we will be covering that on a webinar very, very soon. And we hope you can join us for those webinars. But for now, from me, the team here, Sally and Helen, stay well and safe. And thank you very much for tuning in. Goodbye.